Hey folks, next up on This Week in Law, we're going to talk about PS3 hacking, James Joyce on a microbe, and everything relating to law and journalism, citizen journalism specifically, with two law students studying that very topic, Sarah Berent and Don Mikulastik. And we've got Evan Brown too, next up on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by Cachefly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise Howell, episode 103, recorded March 18, 2011. It's all about media. This episode of This Week in Law is brought to you by FreshBooks, the easy online invoicing service that gets you paid quickly and makes you look professional. Get started with a free package at freshbooks.com. Hello and welcome to This Week in Law. I'm Denise Howell, and we're here this week with a couple of journalism and law students from New York Law School. Thrilled to have them with us from the Legal As She Is Spoke blog, Sarah Berent and Don Mikulastik. I'm going to have you say it one more time. I'm sorry. I tried to get it right before the show.
It's okay. It's Don Mikulastik.
Don Mikulastik. Thank you so much for joining us, you guys. It's great to see you. And also with us is Evan Brown. Hi, Evan.
Hey, how's it going? It's great to be here, as usual.
Great to see you, too. So I am really excited to talk about journalism and the law with you all today, because as I was thinking about having Don and Sarah on the show, I was thinking that there is so much going on in the collision of journalism and law right now. There's so much controversy as more and more people can put things out in the world through various means, whether it's a show like what we're doing today, or just, streaming from their cell phones, or photographing and videoing from wherever they may be, that the question of how you're using my stuff and what you're saying about me is becoming a real primary kind of an issue in our society today. And so I want to get into some of those issues in our stories we're going to discuss. And the first thing I think I want to talk about is the how you're using my stuff point from the citizen journalism standpoint. And that would be my name and likeness, for example, or you can think about so many people are so up in arms about the way that it's so easy to capture all of the moments of our lives these days. You think about sports leagues, you think about the police who don't want to be audio or videotaped, you think about parents who are upset when their minor children happen to be captured on something that goes up online and it wasn't something they approved. So all of this is kind of coming to a head. Don, you wrote a story about someone who was not that excited to find that, or asserts that her name, likeness, and person was the basis for the very successful novel, The Help. You want to tell us what went on there as our lead into this kind of point?
Sure. So Aileen Cooper is a maid down in Jackson, Mississippi. And apparently she works for the brother of the author of the book, The Help. And she's saying that it's her name and likeness that are being used as a character who basically has the same name. It's like Abilene. There's barely any difference in the spelling and the pronunciation. And she's claiming misappropriation and unpermitted use of her name and likeness. So basically, in my article that I wrote, I don't really think that she's going to win with this case. I think that, as much as it might be a similar name, it might be a similar character, I just don't think she really has much of a case, especially having to do with fair use. The author is allowed to kind of draw on her own real life, experiences, and can, I guess the kind of main thing is transformation. She kind of put her own twist on it. She put her own spin on it. and she was able to transform the character enough to kind of deliver the message that she was trying to put into the book. So I don't think that Miss Cooper has much of a chance here.
Right. Evan, do you have any thoughts about whether we need to lighten up in our perception of how our stuff is being used, our name and likeness in this particular case?
I don't know if we need to lighten up more than we just need to be sensible about things in general, because, lightening up would suggest that there's been some kind of trend towards silliness, which I definitely think there is. But what's important here is that the ultimate standard that we need to use to determine whether there's, a reasonable case to bring for like misappropriation of your name, image, and persona or whatever hasn't changed. The funniest thing I think about this case is, isn't it? Is the irony not lost on anyone else that says that the plaintiff here is saying that the defendant held her up to the public in a false light? But wait, isn't it a novel? So it's like a work of fiction in the first instance. So,
right.
But I get what you're saying, Denise. The fact that it's so much easier for us to, well, not necessarily for us, but for information about us to be put out there either by ourselves or by someone else. And it kind of harkens back to what we've talked about before. It's a lot easier for us all to become limited public figures or public figures. We've talked about that in the context of defamation. I think some of the principles in those sorts of thoughts to have about this and the implications of social media and the ability to become more popular can play into the sorts of sensibilities that one should have when they're thinking about whether they're getting ripped off. Sure.
Let me kick this one to Sarah. In the last week, we have seen so much video coming out of Japan and photographs and everything else from the first-person people on the ground during the quake and tsunami. And so the twist on this is not that so much the people in these videos would be upset about being captured, but the people who have made them are finding that they have the nuggets that all the news media wants to use. And that's just how this story has been reported. And I think going forward, it's how news will be reported globally from here on out. So tell us about the legal journalistic ramifications of this. Obviously here the people who are concerned about their stuff are the people who have captured these very poignant and telling bits of journalism. What do you think about their rights and concerns, Sarah?
Well, when you're reporting on such newsworthy events, I don't really think the person who's actually shooting the video is going to be really that concerned with any profit off of it. If you go on websites like CNN, they have this section called iReports where they encourage users to submit videos and submit articles. However, it is subject to their terms of use, which grants CNN a non-exclusive license to alter and edit the material. So any footage that any major news organizations would pick up, I'm sure they're going to have the person who actually made the video sign this license agreement and maybe attribute to that person.
Right. Dawn, do you have any thoughts on this?
Well, I think in today's day and age, it's more, the citizens and the people that are doing all this news gathering, because you can't have the news everywhere at all times. It also goes to, surveillance and stuff like that. We're getting a lot of our video and our news reports now from surveillance cameras and, these kind of hidden, secretive, Big Brother type cameras that are in ATMs and on street corners and things like that. So I feel like it's our world expanding, but at the same time kind of getting smaller because you're able to be everywhere all the time. So it's kind of an interesting juxtaposition.
Right. Evan, I was having a chat with someone who attended the Oscars recently, and she was made to sign all kinds of, basically an anti-social media pact that you would not, you would not be tweeting, you would not be blogging, you would not be taking pictures or video to capture any of the behind-the-scenes proceedings at the event. Do you think that we're going to see more and more of those sorts of strictures as we go about our daily lives?
First of all, I am so impressed that you hang out with people who go to the Oscars. That's great. Good for you.
It's not as impressive as actually going, but
right. Well, for sure, there are going to be more things like this. We've already seen some. It's probably been a couple of years now. I think this was fall of 2009. The SEC, the Southeastern Conference, the athletic conference, tried to prohibit people who were going to football games from live tweeting the events, and that was just laughed out of town really quickly, and the SEC retracted that policy. So it certainly is in the interests of those who are putting on these shows to want to do that for a number of different reasons. One, they want to control the message so that it's perceived in a certain way, in terms of goodwill, and that might be something, with the Oscars. The Motion Picture Academy might want to maintain a certain level of prestige, notwithstanding the fact that Perez Hilton exists in this world and all that stuff, but also for the copyright aspect of it as well, and just kind of this notion of the fundamental reason why purveyors of this kind of stuff want to have that kind of control. That's where we see it at a theoretical level, but at a realistic level, it's just absurd to think that you're always going to be able to manage the behaviors of those people who are there, who now have the capability of streaming live high definition video to the world at large. Perhaps the Oscars is a little bit different. It's going back to how I started my answer to this question, it's still a pretty elite group of people who are there, and they may have their own vested interest in complying with those things. But if it's going to be to a large number of people, a stadium full of people who really want to talk about what they're seeing, it's just not practical to think that those kinds of policies could be enforced.
So the Oscars is not necessarily a public event, except to the extent that they film it and then broadcast it to the public. But there are other things where people can show up, or perhaps like the Oscars, they've been invited or they've bought a ticket, and they're there with their gear, much like South by Southwest that happened this last week. People come and, at that particular event, there is so much filming going on that it's sort of, I think, gauche if you're not walking around recording the proceedings. But not every cultural event has that dynamic going on. And there is a lot of walking around and filming. I think it was last week we talked about the eyeglasses that had the built-in live streaming capability. Yeah. So, Dawn, what do you think about the concerns that people should have when they're engaged in this? Braden Hensey over on our Facebook page at facebook.com/thisweekinlaw was considering the streaming going on from South by Southwest and asking about the legal aspects. If I'm at a public event and there's some music going on a stage, and I'm wandering around and I want to maybe interview some people, and then package something up, either live stream it or put it out after it's edited. What are the legal concerns that I need to have about that as a citizen journalist? And is there anything different about being, a layperson walking around with your non-professional camera and audio gear, or someone who's walking around and has a microphone with a CNN tag on it? Can you try that one for us, Dawn?
Well, I mean, I think that anytime that you're videotaping anything that would be copyrighted, like, music, or, you go into a movie theater, you can't just videotape it. I mean, that's all kind of piracy issues. But I think, for a regular person, you're going to a festival, you want to take a video with your friends, you want to take a little picture here and there, you might want to talk to some people. I think a lot of that will kind of hinge on how you hold yourself out. If this is a secretive, you've got a hidden video camera and you're kind of taking these secret videos and putting them on the internet, I think there's a big problem as far as copyright's concerned. Whereas, like you said, if you're CNN and you have a big camera crew, you're holding yourself out a little bit more publicly. I mean, I think that either way, you're going to have a copyright issue just because this is, especially if you're videotaping the people performing, that's all copyrighted music. I think that you have to be really careful with that.
And it would also depend on whether it's Prince playing in the background or not. This reminds me of the Lens versus Universal Studios case.
Right.
That was the one where it was the YouTube video. The mom had filmed her, infant, very young toddler child kind of starting to dance, could barely walk, dancing, and Prince's Let's Go Crazy was playing in the background. And the big thing to come out of that case was that the Universal Studios should have thought about fair use before it sent a DMCA takedown notice. That's what that's kind of the big thing we've learned from that. And so, that tells us that fair use is going to be a big part of this analysis, and it also tells us that it all depends on how sensitive the rights holder is in all of this. If it's if it's someone like OK Go playing in the background, you probably don't have much to worry about. But if it's Prince, you better not even play a single snippet, or you're going to have lawyers knocking down your door.
Absolutely.
Go ahead, Sarah. You had a thought?
Well, South by Southwest is such like a newsworthy event. It's a big festival. There's a lot going on. So if you had a video camera, we're kind of recording some stuff and interviewing people. I don't really see how you would come into any invasion of privacy issues, because I don't think, anyone would have this expectation of privacy when you're at this big festival and you see all of the cameras everywhere and you're interviewing with someone on camera. I don't foresee that being a real issue. If you put it up on your blog or your website or whatever.
Right. You almost shouldn't be there if you don't want to be filmed or captured in some way. Right. I think, too, it might matter, as we continue on and things continue to develop, it might matter where you post. Because as we've seen on YouTube, they have mechanisms in place now where if you have captured music, or some other thing where there would be a copyright ramification, but specifically they have a program in place for music, that the rights holder has the option of saying, well, we see that this is in fact an unauthorized, unlicensed reuse and incorporation of our recorded work. But they have the option to either leave it there and monetize it, or take it down. So, you as the person who posted it might, never even know. You simply know that your video has remained up, and YouTube is now funneling some of the ad dollars generated by having it there to the rights holder. Evan, do you have any thoughts about that kind of system?
I wasn't listening to the question. I was putting up a link in chat about the Lens versus Universal Studios case, and so I was totally spacing out. So
that's
I passed.
Quite all right. And it is the day after St. Patrick's Day, so spacing out on all of our parts may be to be expected. Right. No, I was asking about. I was saying that where the person who captured the video posts the video may make a difference in this equation as we move forward, because, for example, YouTube has this system in place where rights holders can either opt to pull something down if it's flagged as something that is theirs, or leave it there and monetize it.
Oh, yeah, for sure. Because, all of this is going to have to do with how much it all goes back to control over this stuff. And then, closely linked with control is monetization. So if there is an opportunity or a vector for monetization, that's going to make a huge difference. If something is in a place that is perceived as valid, and I think YouTube, it's safe to say now that it's 2011 and not 2006, is a little bit more valid. Legitimate is the word I'm looking for when it comes to all this stuff. If it's some just strange, site that is setting up pirated streams, there's going to be a world of difference in how the rights holders are going to approach something like that. So context matters a lot in all of this stuff.
Right. And in the context of Facebook, Evan, you had an interesting post I want to get to in just a minute here about using one's identity, I guess, is the best way to characterize that. And we're going to get to it in a second, right after I thank our sponsor for this episode of TWiL, which is FreshBooks. If you're a small business owner, consultant, or freelancer, you probably love having your own business, but you don't enjoy invoicing. FreshBooks is the online invoicing service which enables you to quickly and easily create and send professional-looking invoices. You can upload your company logo to appear on your invoices to give them a more professional look, and your clients can download a PDF of the invoice so they have it for their records as well. You can receive payments for your invoices. Your clients can pay you via PayPal and 11 other electronic payment services, or they can pay using their credit card. There are more options that FreshBooks gives you. There's an automated late payment reminder to follow up with clients. If you invoice by the hour, something near and dear to we lawyers here, the time tracking feature lets you log hours and consolidate your time into one invoice instantly. If you want to send physical invoices for a small fee, FreshBooks will print and mail them to your clients, complete with a return envelope. They charge just $1.39 per invoice or less if bought in bulk. And you can use the FreshBooks iPhone app to track your time and invoice your customers when you're away from the office. Over 2 million users have been sending and paying invoices with FreshBooks since 2004. So try out FreshBooks free today for up to 3 of your clients. It takes about a minute to set up an account. You go to freshbooks.com and just sign up. Absolutely free. Give it a try. Nothing better than kicking the tires and seeing if it works well for you. When they ask you how you heard about FreshBooks, just let them know that you heard about it on This Week in Law. Every day, FreshBooks is giving away a birthday cake to one of our audience members, and it doesn't have to be your birthday to win the cake. FreshBooks draws a name every day for the entire month, so go over to freshbooks.com and check them out. We thank them so much for their support. So, Evan, what happens when somebody tags you in a post on Facebook that is associates your name with a photograph where you had not authorized that and would not have even known that it happened had not Facebook notified you about it after the fact? Somebody took umbrage on this at this and thought that it might actually be actionable. Can you tell us about it?
There are so many great cases that teach us about the law and social media that come to us from domestic relations court. You know, a lot of these are like child custody cases or divorce proceedings or something like that, because, you know, we all know that it's in those kinds of contexts where the best parts of human nature come forward, right? So what we had here was a case in Kentucky where, and it was a divorce proceeding. That, you know, the question was custody. And the wife / mother wanted to, you know, was challenging the court's order that awarded custody to the father. And some of the evidence that the court had considered, the lower court considered, was, you know, some pictures on Facebook of the mother drinking. And so she said that shouldn't have been considered as evidence. And she made a number of arguments, but the most intriguing one for our present purposes here was that she never gave permission for herself to be tagged in that photo. And the court, in dispensing with rejecting that argument, said an interesting thing here. It said there's nothing in the law that requires a person's permission to be given before a photo of them is uploaded to Facebook, and there's nothing in the law that requires permission to be given before they are tagged. And that's like I say, that's interesting. It's kind of fun to talk about. I think that there's a certain danger in overstating that or putting too much emphasis on what the court said there. We shouldn't look at this as a wholesale kind of per se endorsement of tagging and saying that is always going to be okay. There's this adage that lawyers throw around, bad facts make bad law. We should not assume that the law says that it's always appropriate to tag someone in Facebook without their permission just because of what this case in Kentucky says, because there are some kind of, the facts aren't on all fours with, the real issue is whether you really need that permission. It was a little bit ancillary here. I think there are all kinds of situations where a person could could have a cause of action against another person for tagging them and putting them up on Facebook. For example, you share a photo with somebody in confidence that shows you in doing something, and there's an expectation that the contents of that photo will be kept confidential. Just use your imagination. What kind of subject matter could be in that photo there? And if the expectation and the agreement is that will be the private facts, and that will be confidential, and that is put on Facebook and tagged, and the person is tagged, and then that information is seen by the person's social graph. There still might be a cause of action for, I don't know, false light. I don't know if it'd be false light, invasion of privacy, but publication of private facts, intentional infliction of emotional distress. Maybe there could be some copyright issues there. That tagging, to the extent that tagging facilitates the distribution of that photo. So it's interesting to think about this concept about whether or not you really need somebody's permission to tag them on Facebook. But I don't know that we learn a whole lot from this case, other than, at least in some circumstances, the court is not going to listen to the argument of somebody complaining, "Hey, I didn't consent to this." That's going to be all right, at least in some circumstances. So it's something fun to think about.
Yeah, it is. It's an interesting conundrum, especially because on Facebook, of course, you've consented to people tagging you, but it's one of those issues of, who reads the terms and conditions, and they're a bit complicated to understand. Sarah, any thoughts on this one?
I think Facebook gives you a lot of ways to detag photos, or to even eliminate the option of having photos tagged of you. So, there's a lot that can be done within the site itself to eliminate the spread of, I guess, your image or your name attached to certain images. The courts don't necessarily have to get involved.
Right. In our IRC here, we have a related point coming in from PC Guy, who says, this via Twitter, tell me you didn't see this coming. Starting tomorrow, Facebook will use your photos in ads. You have to go to account settings, Facebook ads, and choose no one in order to make sure that you're not actually showing up in an ad. So there's certainly a use that goes beyond just another user tagging you. It's an appropriation of your name and likeness in a way you might not have expected, but agreed to, because of course everyone agrees to the Facebook terms of service. Dawn, do you think that that's a nice situation to be in, that folks have just clicked agreed, and that Facebook can usurp their expectations by deciding to throw a switch and start using people's names and photos in ads?
I don't think it's a nice thing, but I think something that, you kind of agree to as being, a creature of this social media. People put themselves out there everywhere. And, I have a lot of friends that actually, when you try to tag them, it says, well, this person is not allowed to be tagged until they approve the picture. So there's ways to protect yourself. You just have to be a diligent social media user. This also goes along with one of the stories that you posted about Foursquare, and, people getting so up in arms about people being able to contact them or reach them or know where they are all the time. Well, then don't check in on Foursquare. It makes no sense that people are so crazy about their privacy, but yet they put their whole entire lives on the internet for everyone to see at any given second.
And then blog about the fact that somebody contacted them after they checked in somewhere on Foursquare. So, yeah, none of this should really come as a surprise to us. It's with the what you were talking about there was a post by Brad Feld, where he kind of recounted his spooky experience at a restaurant in Boulder after he checked in there, and somebody called the landline at the restaurant, and the manager came over and handed him the phone, and it was this muffled voice saying, "I know where you are." So, we've talked about that scenario in the abstract or as a hypothetical, ad nauseum in the past. So it's, why are we so surprised, or why should we be surprised or shocked when it actually happens? And, with the Facebook using images for advertising purposes, that shouldn't come as any surprise either. They have, it's their practice to kind of really be grabby, and it's Facebook's practice to kind of be grabby in the rights that it wants in the intellectual property of its users, and then often they'll retreat in the again, when in the face of resistance from the user base. But there have been it's been in the I just remember in February of 2009, there was a big outcry over something that they had done. And one of the things they tried to do was grab a perpetual license from the users, not only in the copyright of that, but also in the rights of publicity of the users, forever. And the doomsday scenario in all of that was, you could be driving down the interstate 50 years from now, and you could see a photo of yourself on the billboard that you uploaded to Facebook way back in 2008. So, the fact that they're wanting to exploit these kinds of rights and to leverage them to make money or to support the platform is no surprise to me whatsoever. And we shouldn't have too much indignation now that it's happening or it's imminent.
Right. Okay. Well, let's talk more about this whole overarching journalism theme that we've been on for the show. And let's talk next about kids. And let's go to Sarah and just sort of ask you the general question as a mainstream journalist or a new media journalist or a citizen journalist. What sort of things do people need to bear in mind when children are the subject of either the video they're taking or the story they are reporting on?
Well, I think, you would want to obviously be more sensitive than you would if it was an adult, and kind of, more or less use common sense as to whether or not you want to post the actual video of the child, because it is a child, and the child obviously doesn't have the mental capacity as, a normal consenting adult. So I think that would have to be up to the judgment and the common sense of the person actually taking the video, and to, maybe think if this was their child, would they want this on the internet?
Mm-hmm. We've got, of course, children being more engaged online with the consent of their parents under the acts and regulations that govern children, including COPPA. Recently, Disney acquired a social network that's aimed at kids, something called TWiL. Evan, do you have any concerns having a big media empire like Disney running social media type sites for children? They probably have numerous other such properties. This is just the latest addition to the stable. Any sort of additional concerns when it's such a huge conglomerate that is collecting and managing children's online presence?
Yeah, there's a couple of ways we could look at this. One is to be fearful of it because it's, like Leviathan taking all of this information and it being lost in, some kind of monolithic brain that is Disney and all of this, and maybe used for whatever evil in the future to market to those kids as they're moving along into adolescence and adulthood. So that's perhaps a more cynical or closer to cynicism on the spectrum of the types of reactions that one could have. A more positive response to it could be, well, wait, this is Disney. The response in both of them could be, wait, this is Disney. And you could go from there and saying that it's bad. Or you could say, wait, this is Disney, and look, it's good. Disney has been entertaining children for years, and look at all the people who have grown up to be normal adults because of Disney doing all this. And along those lines, you can say, because they're a large enterprise with a lot of resources, perhaps it's more likely that they will more effectively manage this and be more of a responsible corporate citizen and I realize by saying this must be just absolutely inviting tomatoes to literally be thrown from the IRC from this to talk about, a responsible corporate citizen and maybe doing the right thing. But, maybe because of the resources that are there, they will implement the right policies and the right framework for handling privacy and taking it seriously, not only under U.S. law, but under the EU directives and, the restrictions in Asia and wherever else. So when it comes right down to it, I don't know what to think of it. I think that there could be plenty of worse things that could happen with our children's privacy than Disney having some of that information. So I suppose on balance, I'm more toward. I don't necessarily think it's a great thing, but I'm not like running scared, and I don't know whether I would keep my kids as they get a little bit older from doing something like this Togetherville thing.
Right. Well, if you want to have a good example of something that might be worse about children's privacy, it's a local school district here to me in Orange County, California. I believe it's the Anaheim School District that is giving 7th and 8th graders with 4 or more unexcused absences a handheld GPS device that looks like an old school cell phone. That, makes them check in, if you will, with their school simply by carrying this around with them. And this in the wake of course, the Pennsylvania case last year, where students' school-issued laptops were having the cameras flicked on, or there was a lawsuit about that at any rate, to spy on the kids. So GPS for truant kids. Dawn, what do you think about that one as a student yourself?
Well, I also just wanted to go back to what we were just talking about and touch on one thing about the Disney kind of interactive media. I think that mostly falls on the parents, because if you're a responsible parent, your child cannot access the computer without you being there and without you, unlocking the password or allowing them to be on and monitoring their use of that. So I feel like that really falls on parents to monitor their children, what they're doing on the internet, because they shouldn't be able to get on the internet without the parents, kind of knowing what's going on. Again, I kind of feel like that's the same issue here, where I don't think it's the school's responsibility to track down the children and make sure that they get to school. I know, of course, parents can't keep track of their kids all the time, 24 hours a day, 7 days a week, but that really falls on the parents' shoulders to be responsible for their kids. Why are their kids able to be truant from school, or, to be absent and, playing hooky all these days in a row, and the parents are doing nothing about it? I kind of feel like this is crossing a little bit of a line between the school's responsibility. I mean, where does it stop? The kids have to, it says they get wake-up calls and, alerts and stuff to their phone. Like, this is kind of ridiculous. I'm an adult and I'm in law school, so I, can come and go as I please because I'm paying for it. But ultimately, I feel like it's the parents' responsibility to get their kids to school, and I don't think that the school should have to really be burdened with this.
Or why can't the school just have someone physically check into the classes instead of giving them a GPS device? It just seems more inherently invasive than, having a student sign in an attendance sheet, or having a school administrator just checking in 5 times a day to make sure that student is in class. These GPS devices seem unnecessary.
Yeah, and it's something that, we're looking at a story here from Mashable by Christina Warren in our links at delicious.com/thisweekinlaw/103, where you can see all our links for this week's show. And we don't really see from this, what sort of parental consent is required for this kind of a program to be in place. But I would think that would be a really important aspect of this. There are contexts where I could see GPS for a kid being okay. We recently went on a ski trip, and the kids are off with their instructor for the entire day, away from their parents and out on a mountain that's full of, chest deep snow for them in the particular place we were, going off in trees. And they were saying at this particular mountain that, next year they might well offer GPS for kids in that circumstance, which, as a parent, I would go right on, wonderful. I don't want my kid getting lost on the mountain. But as far as a school mandating that the children have to carry around GPS because they, you're right, the unexcused absences thing is completely a parental issue. But we've got, to keep an eye on this kind of thing closely, I think, and make sure that if it's going to be a government agency like the school system saying we're going to track your kids, I think there's some alarm bells that should go off for a parent in that situation. Let's go on and talk about, I don't know, Evan, what do you feel like talking about next? We have a lot of links this week. Evan Brown?
Oh, sorry, I pulled a Colette. I was excited to talk about James Joyce and his grabby estate and artificial life and the copyright implications thereof.
Oh, let's do that. Yes, you sent this one in.
Yes,
So
this was this is an interesting situation where what was the guy's name who came up with the synthetic bacteria? Craig Venter. When he came up, with this artificially manufactured genome in these bacteria, he cleverly, I don't understand precisely technologically how he did this, because I know that there are only certain amino acids that are in the genetic structure that only have those 4 letters there, or whatever. I had to drop out of genetics in college. Sorry. So he somehow encoded into the genome this very short passage from one of James Joyce's work that said, to live, to err, to fall, to triumph, to recreate life out of life. Somehow encoded that into the genome. And he gave a talk, Venter gave a talk at South by Southwest this year. I was just making sure that it was Venter doing the one giving the talk, and he told this story about how he had done that. And what he said was that when news of this came out, he got a cease and desist letter from James Joyce's estate saying that he should have gotten permission beforehand before he actually used this short snippet of work. And then I guess we need to stop and consider, did he really use that snippet of work by encoding it into the genome in this way? So what we have here is a really wonky kind of question as to what it means for a work to be copied. And there are a number of different ways we could take this discussion. Some of the questions we could ask, is it really copyright infringement to be appropriating James Joyce's work in this way by encoding it into the genetic sequence, something that never will be seen? So there's a question of whether or not it was really reduced to a tangible medium of expression, which goes to the question, was really there a work? We could also spend time talking about fair use and other questions of infringement, that goes along these lines. But I just thought this was a really wonky situation, a really interesting example of all this that raises some interesting copyright questions, and then it could also raise some questions about whether the James Joyce estate continues to have poor judgment in the way that it's aggressive towards scholarly use of its works. It certainly would not have been the first time that James Joyce estate would have been in copyright litigation over scholarly use of its work. So I just thought this was really a neat little situation.
It is. It's wonderful to see, as the writer in our link said, millions of little acts of copyright infringement as the microbes multiplied. Dawn, any thoughts about this one?
I actually love this article, and I think it's such an interesting idea. I think that obviously, what Evan was saying is that it's not really even copyright infringement because it's not put out there. It's not really, fixed. And it's on DNA. It's like goat DNA or whatever.
Like de minimis.
Yeah, exactly. Like who's ever going to see that? But I was thinking of interesting ways to try to fight against it and say, fair use. It's really transformative because every time that the genome mutates, it, it's slightly different, and maybe the letters get, skewed a little bit. I mean, really, it's kind of silly, but I think that it's a really interesting take on, just how nitpicky people are getting, and how, they're trying to take this copyright thing to the next level. And I mean, are you going to get copyright infringement for having a tattoo on your skin, but then if you gain weight and it stretches, then it's transformed? And, you know what I mean? It's just so silly and so out there.
Sarah, I'm so glad you mentioned de minimis, because that's what I was thinking in all of this. I guess, in the article that we have about it that are in our show notes for today, Venter is reported to have said that he thought or thinks this would be protected by fair use. And that certainly is the argument that was raised in the litigation. It was Professor Schloss, right, that from Stanford a couple years ago, when the Joyce estate was being aggressive and trying to stop her from using excerpts from Finnegan's Wake and other works and some scholarly works here. She, had Stanford CIS, Larry Lessig, Tony Falzone, and Mark Limley, among others, helping her out, and they settled that case against the Joyce estate and its aggressive copyright posture. But with this, I don't even know that we would need to get to the fair use analysis because of what you said, Sarah. It's de minimis copying, and the de minimis defense to a copyright infringement matter, it asserts that there is no infringement because the two works, the original work and the work as copied, are not substantially similar because you're only using such a tiny little portion of it. Fair use, on the other hand, is an affirmative defense, and procedurally, and I apologize to the listeners for getting too much into the procedural legal nuances of all this, but an affirmative defense under the way that litigation plays out assumes, for the sake of argument, that everything that the plaintiff says is true. It's like, yes, this is an infringement, but it's okay because it's a fair use. So we can talk about, the transformative nature of the work and the fact that there was just a little bit of it used, and it doesn't, think about it, it's not going to replace, somehow usurp the market for James Joyce's works. People aren't going to buy these bacteria and not go to Borders and save it from bankruptcy by, pulling a copy of Finnegan's Wake off the shelf. So we can think about it in fair use, but I think a court could do away with a lawsuit over this even without getting to the fair use question, because of the point of it's just de minimis copying, and it's not, you don't even have to admit for the sake of argument that it's infringement.
I don't know, Evan. I'm envisioning a whole new kind of BitTorrent where somehow people are gathering up all the microbes and reassembling the work.
Oh, geez. That's great. You can read it. Maybe it's a new model for Netflix. They just send Petri dishes. I don't know.
That's right. It looks like a disc. All right. Well, I wanted to get to a question for our law and journalism students that is near and dear to my heart, because one of my favorite ways to start the day is to check out damnyouautocorrect.com. So hysterically funny, and for anyone who has not seen it, it is a site where people take screenshots of mostly their iPhones, it seems like.
Well, iPhones are first with autocorrect. Their autocorrect
right, exactly.
is just really bad compared to BlackBerry or any of the other phones. In my experience, they come up with these absurd words when you're typing text messages. It's
right.
Funny.
Putting absolutely hysterical things in people's mouths or at their fingertips that they never meant to say. And, taking screenshots of the particularly wonderful ones and posting them up on this site. And the site, as I understand it, is about to, surprise, surprise, publish a book, a compilation of all of these things. And Evan, this goes to the question we've asked on the show before about, and the de minimis point that we've been making with this prior story. The question about whether tweets are copyrightable. Now we're, I guess, down to the micro level of text messages about that same volume of characters. Can they be copyrightable too? And again, this whole aspect of needing to get permission from folks, because when you have one of these hysterical moments, you take the screenshot, you send it in, I doubt there's a lot of permission being asked for or gained in connection with a site like this. And this, by the way, is not the only kind of site like this. There are so many examples out there now of people capturing these little moments in their lives that are absurd or funny or what have you, their interactions with other people that they've either been part of or overheard, and sharing them online. The guy who became the TV impresario of S word, my dad says, started out on Twitter. Same kind of idea. So let's go to Dawn first. What do you guys think of this kind of phenomenon? And, if you were confronted with this scenario on a law school exam, what would you say to the person compiling up these images and wanting to publish a book?
First of all, you have to look at the content of the text messages. Obviously, there's little things that aren't meant to be there, misspellings and funny little quirky things that happen with the autocorrect. But let's say that you were texting somebody the lyrics of a song. I don't know if you'd really have much of a case for copyright infringement there, but you really have to be careful when you're putting anyone else's work out there, even in the form of, this kind of autocorrect, ha ha ha, it's so funny. Because if you're only changing 1 or 2 letters to make a word different, you're not really changing the whole thing. That being said, you can also say, hey, look, this is a parody. It's obviously meant to be kind of a spoof and be funny, and look at the use and what we're, trying to do with it. But, I think also maybe somebody's texting you, this poem that they wrote and that they have copyrighted and they want to put into a book, and then you're throwing it in a book and putting it on the internet. You just have a lot of issues that you have to be careful with.
Right. And also a lot of times on websites, when you post something, your posts are subject to the website's terms of service. And if, this particular website with the autocorrect text, has a clause in their terms of service saying that you're basically giving up your copyright ownership in these text messages, then as Facebook does with the pictures that you upload, then I think, your claim would probably be limited in that sense.
I think that this particular site is interesting because there is a definite journalistic implication to what they're doing, and that is an indictment of how poorly autocorrect works. Right. And so, there is definitely an editorial comment being made simply in the existence of the site. So that, apart from whatever permission they're formally obtaining through their terms of service, I think that they actually have, a journalistic function here that might well protect them too. What do you think, Evan?
Yeah, there's a number of different things I think about all this. That's good, the journalistic perspective of it and justifying it, in that way. And I think we could also kind of examine the question of whether or not, this stuff is copyrightable in the first instance in this way. I know we were talking about, the whole looking at it from the Twitter example. I love thinking about the copyright implications of the semantic web, and at a very kind of rudimentary level, autocorrect is an example of semantic technology where it's the technology is considering what it thinks you mean. So there we get the semantic aspect of it. And I've often pondered, as works can arise through interactions of data on the semantic web, then they're assembled in such a way that it does not necessarily reflect the intention of the user. Is there really a copyrighted work there to begin with? I characterize it as a separation or an evolution that results in a separation between author and work. So if and this could get kind of silly in our discussions with it here, but if you're going to be uploading something, or let's just say if a screenshot is uploaded where you are the one who was not the victim of the autocorrect, but it's the person with whom you were conversing, you could say that the resulting work that came out, because of the effect of the autocorrect, isn't truly a work of that other person, and so therefore there are no copyright implications at all, which plays into what we're talking about, looking at this from a journalistic standpoint or from the standpoint of critique or otherwise, that all just plays in as much as it is the subject matter of what indeed is being critiqued or talked about with all of this stuff.
Well, I think we all agree that the stuff that gets posted to Damn You Ought to Correct is just a joy, and we love having it in our lives. And, I love checking in with it and just chuckling to my heart's content. But people are less sanguine about the short messages they're receiving from telemarketers on their phones. Sarah, was this your story on Legal as She Has Spoke?
Yes.
About telemarketers and text messaging? Why don't you tell us about that and the legalities involved?
Well, it turns out that any unsolicited text message from a company that has this automated capacity to send out mass text messages are illegal. There is the, sorry, the lights just went out in our room. Oh, they're going back on. Sorry about that.
But you paid the bill.
There is the Telephone Consumer Protection Act, which protects you against receiving any unsolicited text messages. And you don't have to necessarily incur a charge for the text message. It just has to have been sent out through a system that sends out mass text messages. So, which is good for everyone to know that they are illegal.
Yes. Is that under anti-spam laws, or has there been new law enacted that specifically deals with this kind of communication?
There was the Telephone Consumer Protection Act. I'm not sure when it was passed, but it didn't specifically include the word text message. It just had the word call in the statute. It was illegal to send any unsolicited calls. However, recent court cases have interpreted the word call to include text messages. So that's where this has come from. There were cases where movie studios were sending out text messages to promote their films. The case I wrote about was Wenner Media, which is the parent company of Rolling Stone, and some other magazines were sending out unsolicited promotional offers via text message. So there's been quite a few recent class actions against these text messages, and they have been found to come within this act. So good to know.
Right. How about robot calls? Do you think that would come within this act as well? So if it's not actually a person, it's a mechanized kind of, because I get tons of those on my cell phone.
Yeah, well, the statute criminalizes it's not necessarily that it has to be a person. The company that's in charge of making these phone calls or text messages have to have the automated capacity to send out calls or texts, en masse. So, the fact that it's a robot or a person doesn't necessarily matter as much as the equipment they were using had the capacity to send out, all these different texts or calls at the same time. Mm-hmm. And I know that you can opt out. There's a do not call registry that you can sign up for, so you'll avoid any of these telemarketing calls or text messages.
Right, in theory.
Right,
Some get through. Evan, what do you think about this notion of making this kind of conduct illegal? You're our ace person at finding the exception to when there's a law and having it be an appropriate application. Can you think of examples of when there would be a mass communication that some entity might want to make that society as a whole would agree is a good thing and should not be, I want to say criminalized. I don't think that there are probably criminal penalties for this, although who knows, maybe there are. I haven't looked at the statute. What do you think, Evan?
I think the low-hanging fruit on this would be, looking at it from some kind of First Amendment issue. Do you have some kind of First Amendment right to broadcast something? And I'm led to, and I realize this is not the perfect First Amendment analysis, but at least in my thinking, I'm thinking imperfectly, as I often do here, it leads one to consider the public interest, or, the compelling government interest, which, hopefully in most circumstances is going to be, have the same contours as the public interest here. And so shouldn't there be some kind of exception to make these communications when the public interest is clearly at stake? Let's suppose there's, I don't know, I'm going to use my imagination, a huge a natural disaster that causes extensive damage to a nuclear reactor. Totally making this up.
Right.
And you need to distribute iodine pills to everybody, and you need to let them know where they need to go pick up those. Those is iodine pills, right? It's some kind of iodine.
I think it's potassium iodide.
Potassium iodide. So probably much
different. People here on the West Coast are quite freaked out about this right now.
Yeah,
so I'm aware of the name of the substance, which apparently, so I'm told, is completely out of supply on sites, where you would buy vitamin supplements, etc. And bottles of it are now going for hundreds and hundreds of dollars. But
right.
Go on.
So maybe it would fit best on the shoulders of a non-governmental entity, somebody who otherwise would be, on within the constraints of this legislative regulation, to have the ability to make those types of communications for the sake of the public interest, when otherwise they would be prohibited along these lines. So again, you can see where my thinking is a little bit imperfect. That's not purely a First Amendment question, but it certainly is a situation where a type of speech that would otherwise be regulated by this should be permitted for whatever countervailing interest is there.
Right. All right. Well, thank you for that. I want to get to one more story from the Legal As She Spoke blog, and this one that Dawn wrote up about hacking the PSP. And, generally when we think of jailbreaking these devices, circumventing protective measures that are in place, it's a pretty straightforward DMCA violation, and folks have been prosecuted for it in the past, and Microsoft has been pretty aggressive over the years, except when it comes to its Kinect. It's being a lot more tolerant of these sorts of activities. But apparently Sony, with its line of game systems, is not being so tolerant. Dawn, can you tell us about this case and why you think that Sony has a problem here?
Sure. So Sony is suing George Hotz. He is a local New Jersey gentleman who put on his website the keys or the code to jailbreak the Sony PSP or PS3. I'm sorry. And basically, this is a way to get around the barriers, and you can kind of break your PlayStation so that you can play like any game that you want. You can, you don't just have to play Sony games, and you can kind of unlock it, similar to the iPhone jailbreak. But basically, the DMCA, their laws are meant to criminalize, the acts of getting around the barriers to copy certain material. It's not actually just getting around the barriers. And I think that, Sony's going to have a problem, basically saying that only unlocking or jailbreaking the console is illegal, because I don't think it is. I think, they have the right to say, hey, look, we void your warranty. We're going to kick you off of our system, which they actually did. They kicked everyone off of, whatever like the world is that you get to go to. And it's kind of the online where you play games against different people. So, if they find out that you've jailbroken your console, they can kick you off of that. They can void your warranty. But I don't think that they have a real case here against, HOTS or any of the users that actually jailbreak the systems.
Yeah, that's fascinating because, in many of these instances, folks have been able to go after hackers and prevent jailbreaking. And we've needed things like exemptions from the Copyright Office for things like jailbreaking the iPhone to make sure that that is okay. So, Sarah, any thoughts on this one?
No, I just think it's, fascinating and interesting that there are all these ways to bypass the, the intended product to, with the iPhone, so you can use certain applications, or even, the PS3. I don't see them actually copying anything. It's just they're, kind of hacking into the software itself.
And there's actually an interesting video that I linked to in my article, and it's, it's saying, look, what if you bought a car and you were only allowed to get gas at the, manufacturer's approved gas station. You're only allowed to listen to manufacturer approved radio stations in the car, manufacturer approved tires. I mean, it's kind of a control issue. And the reason that the DMCA made this exemption for the iPhone jailbreaking is because they were like, look, we don't want to aid them in completely controlling everything that people are doing on their iPhones.
And there was, an interesting copyright case where it was like the maker of a garage door opener was suing the maker of one of, the universal garage door openers for being compatible with the system.
You're asking my addled, aging brain to go really far back to come up with the name of that case. Evan, do you have it at the tips of your tongue?
Don mentions it in the article here. It's the Chamberlain case from here in the Seventh Circuit. There we go. Yeah, this is going way back, 2004. That's it.
So far.
Yeah.
But it was an interesting case, and they didn't find copyright infringement because I think that, they said it would be, I guess, inequitable for the Universal Remote to actually get a license from the maker of this garage door opener. Am I correct in that analysis?
Yeah, I mean, she recognized this important connection between the anti-circumvention provisions in 1201 and the trafficking provisions there. To recognize the important connection between that and the underlying copyright interest. So to the extent that the access being prohibited or the protection being given doesn't pertain to, the risk or the actual infringement of that work taking place, it's not actionable under Section 1201. Which, amazingly, I think that's a great ruling, and it makes a lot of sense. But honestly, I think that's a pretty strained interpretation of Section 1201. But we've seen other courts do similar stuff with it. The Lexmark case out of the Sixth Circuit a couple years later, and then there was just a case from, I think it was out there in the Ninth Circuit, right? It was at the MDI case that came out. So we certainly see a trend in this way, and the positive thing for us to take home from that is it does seem to temper a little bit of the outrageousness that people see in the anti-circumvention of the DMCA. It tempers it so that the courts actually are reasonable at some points in recognizing this connection with the fact that it is part of the copyright law, not just some form of new form of liability that comes out of left field from space or something.
All right. Don and Sarah, I never got an email back from you, so I want to make sure you're ready to do this. I asked you guys if you might want to do our tip of the week this week. Is that something you're prepared to give us?
Well, our tip of the week for you, if you're a citizen and you want to do something with journalism, you have a picture, you have a story that you want to put out there, we suggest that you go to sitmedialaw.org. It basically tells you everything you need to know, different states, different regulations, all the different protections that are offered for journalists, shield laws, and that kind of stuff. And it's a really, really helpful website that we think that you should definitely consult.
A lot of privacy laws vary state by state, and this website actually gives you a great breakdown of, wiretapping or eavesdropping or recording audio and video. So it's a great resource for anyone out there who has a desire to post their material online.
And one thing that I'd said before too, going back to that, it's a lot about putting yourself out there and holding yourself out to actually be recording or, videotaping something. I mean, it's not in anyone's best interest for you to be snooping around and, trying to be some sort of sleuth and put stuff on the internet or, you could really get yourself into trouble that way. So if you're going to take a picture, if you're going to interview someone, let them know that you're doing so and try to get as much permission as possible so that you're not held liable.
Wonderful. Thank you so much for that. Yes, we love sitmedialaw.org and the blog they have there. Wonderful project and incredibly useful for folks engaged in any form of citizen journalism or media. So thanks so much for that. We have a couple of resources of the week for you to check out. One is from the law firm of Morrison Forster. And again, it's linked in our delicious links for the show. It's called Privacy in the Cloud, a legal framework for moving personal data to the cloud. It's a guide for businesses. So if this is something where you're moving personal data to the cloud and you are a business, you're going to want to check this out because it's a really nice guide for that kind of activity. And one other resource to check out, something that's been causing a bit of controversy in the legal world, as new things in the legal world tend to do. And it was started by a 21-year-old law student named Robert Grant Niznik, if I'm pronouncing his name correctly. And he has come up with something that's sort of an eBay for lawyering. It's got a really, really strange name called Spoonkle, SHPOONKLE. And it's a way that if you have a legal problem, you can get lawyers to bid on taking that work, and what they're doing is sort of bidding down so that you can find an attorney that fits your budget for the problem. So check out Spoonkle if you're interested in a new way to locate legal services and a new way that lawyers might provide them. And with that, I'd like to thank our wonderful panelists for joining us today. You guys have had great insights, and I really appreciate your joining us on the show. Dawn, I know you're on Twitter at Donnie Pony. Any other sites besides Legal As She Is Spoke, your wonderful blog, you'd like to plug before we wrap up?
Well, no, you can follow us on Twitter at LASIS_blog, because that's where we post our updates.
Absolutely.
Wonderful. Thank you so much. And Sarah, great to have you too. Appreciate both your good work over at your blog, and we'll continue to check that out.
Thank you so much.
Thank you.
Evan, great having you on again as well.
Well, I have certainly enjoyed it. It's been a lot of fun, a lot of interesting things to talk about, and it's been great talking with you, Sarah, and Dawn. Good luck with finals and all that stuff.
Thank you.
All those fun law school things.
Yes, thanks for taking the time, you too. And folks, do follow Evan over on Twitter. He's Internet Cases on Twitter, and of course his wonderful blog at internetcases.com. We'll see you next week for the next episode of This Week in Law. Take care, all.